Senator Kennedy to kick us off.
Thank you, Madam Chair. Judge Dudick, did I say that name right?
That's correct, Senator.
All right, what's the warrant requirement?
Well, before the court would issue a warrant, you have to assess to make sure that there's probable cause to either search the place.
When's a warrant required?
Excuse me?
When is a warrant required?
The general rule is a warrant is required any time that the government wants to search a person, place, or thing.
Could you speak into the mic?
Oh, I'm sorry, Senator. Yeah, I said the backdrop rule is that a warrant is required any time the government wants to search a person, place, or a thing.
And to arrest you, right?
There are some exceptions to that, but generally, yes.
Okay. And there are exceptions to the warrant requirement for searching and arresting people, are they not? Are there not?
Yes, Senator, there are.
Okay. Suppose the Florida Supreme Court ruled that here in Florida, we're not going to recognize any exceptions to the warrant requirement. You have to have a warrant to search someone, and you have to have a warrant to arrest someone. Mm-hmm. No exceptions. Can the Florida Supreme Court do that?
Well,
Patriots, what we just witnessed should concern every single American who loves this country, respects our Constitution, and believes in the rule of law. Senator John Kennedy just exposed a terrifying reality. The people being nominated to federal courts, positions of lifetime power, don't even understand the Constitution they swear to uphold. And I'm not talking about some complicated nuance here. I'm talking about basic, foundational rights, like the Fourth Amendment, the Supremacy Clause, and the Civil Rights Act.
Court do that?
Well, Senator, under the Supremacy Clause, they'd be bound by what the Fourth Amendment dictates. Of course, they're free to make their own requirements as it.
What if the Florida Supreme Court did it under the Florida Constitution and not the federal Constitution?
Well, they would still, Senator, have to apply with what the federal Constitution said.
No, they wouldn't.
Under the Supremacy Clause.
Do you know what adequate and independent state grounds means?
Sure. Of course, I would understand that they could have independent and adequate state grounds for state law, but they.
No, they don't. As long as you don't take away rights, but add to them, a state can do whatever it wants to under its state constitution, can it?
Yes, sir. Yes,
That's
Senator.
not what you just said. You think the Supremacy Clause applies? The Supremacy Clause applies.
Well,
you want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature or Florida could do exactly what you said. I meant in my statement is that.
Trust me, it can. Judge Pruitt, I'm sorry, I can't see that far.
It's Judge Pratt, Senator. Yes.
Judge Pratt, I apologize. I can't see that far. Can a state legislature pass a law that discriminates against a group of people over another group of people for inferior treatment?
Well, Senator, the federal Constitution and the state Constitution both contain protections against various forms of discrimination.
But can a state legislature say we're going to treat this group of people differently than another group of people?
So I think, Senator, an example where a legislature
could. Tell me first
if
a state can do that.
Yes, a state can, for example, require a driving age which discriminates on the basis of age. To say, for example,
when can a state legislature not do that?
When it's seeking to do so under a basis that is protected under the state or federal Constitution.
Okay, good. Judge, tell me about the privileges and immunities clause.
The Privileges and Immunities Clause, there's a privileges and immunities and a privileges or immunities clause. There's one of each. One of them relates.
Privileges and is what I'm asking you about.
I believe you're referring to what came through in one of the Reconstruction amendments and discussing the fact that that the privileges and immunities of citizenship would be extended
Well,
under those.
first, what article is it in?
I believe it's in the 13th Amendment.
No, fourth. Article 4. What does it do?
Senator, you have pinpointed a question that in my 9 years as a judge, in my decade of private practice before this, my 2 years as a law clerk, my 2 years on law review in law school, including a year as editor-in-chief, didn't ever come up.
You tell me you don't know?
So it's an interesting question.
Yes,
and
ma'am. I know it's interesting. That's why I asked it.
Yes,
but you don't know the answer. Just tell me. I got a lot of ground to cover here.
I would be very happy to research it.
Okay. Do you know what the privileges or immunities clause is?
With respect to my answer would be the same on that.
You don't know it either.
Well, with respect to the privileges and immunities of citizenship, my recollection is that
Privileges are immunities.
yes, my recollection is that was discussed in one of the Reconstruction amendments.
Which one do you know?
I believe it was the 13th to the 14th.
Okay. All right, Judge. What's Title VI of the Civil Rights Act of '64 do? Ma'am?
Which judge?
This judge down here on the far end.
Artau?
I can't see that
Okay.
far.
Just making sure, because there's 4 judges there. Judge Artau, I'm going to let you answer that briefly.
Hey, I want to reclaim my time, Mr. Chairman.
You can
Madam
answer that
Chairman.
briefly.
Judge, what's Title VI of the Civil Rights Act do?
I believe that ensures that people are treated equally in any places that they would be, that they would not be discriminated against.
In all cases?
Refresh my recollection as to what you were referring to,
I'm
Senator.
referring to Title VI of the Civil Rights Act of 1964, which you're going to see every other Thursday as a federal judge.
So I believe that's under the Commerce Clause. They wanted to make sure that there was not any discrimination going on with regard to race, and that was addressing
it. It prohibits discriminating on the basis of race or color or national origin. Under what circumstance? Do you know the answer?
Under any circumstances where you're providing services to people.
No, it's only if you're getting federal money. You need to brush up on that one. I'm way over my time. Thank you, Madam Chair.
Thank you, Senator Kennedy. Senator.
Let's start with the basics. Senator Kennedy asked the first nominee, Judge Dudek, a simple question. When is a warrant required? And guess what? She fumbled through the answer like a first-year law student. Look, the Fourth Amendment of our Constitution is not optional. It's not complicated. If the government wants to search you, your house, your car, they need a warrant. That's a fundamental protection against tyranny. Now, Judge Dudek did eventually get it out, kind of, but this is the kind of answer that should be instant for someone who wants to be a federal judge. If you hesitate on basic rights, how can we trust you to protect the rest? Then things got even more embarrassing. Kennedy asked about the Supremacy Clause. Folks, this is day one constitutional law. The federal Constitution is the supreme law of the land. It overrides state law. But Judge Dudek got tangled in her own answers so badly that Kennedy had to correct her multiple times. She didn't understand the doctrine of adequate and independent state grounds. For those watching who aren't lawyers, that's the principle that a state can offer more rights than the federal government, not fewer. But again, this nominee didn't know that. This is Constitutional Literacy 101. Next, Kennedy grilled another nominee, Judge Pratt, about whether a state legislature could discriminate against a group of people. Now, of course, the answer is no if it violates the Constitution. But Pratt danced around the answer with some nonsense about driving ages. Folks, this isn't about whether 16-year-olds can drive. It's about whether a state can target people based on race, religion, or gender. The answer should have been clear. No, Senator, that would violate the Equal Protection Clause. Boom, done. But these people just don't know what they're talking about. Now here's where it gets downright shocking. Kennedy asked about the Privileges and Immunities Clause. That's Article 4 of the Constitution, a foundational piece of what keeps America a united republic. And what did the judge say? I think it's in the 13th Amendment. Wrong. Dead wrong. Article 4 is what ensures states can't treat non-residents like second-class citizens. And the Privileges or Immunities Clause, yes, there's a difference, is in the 14th Amendment. The fact that this judge, who went to law school, clerked for a federal judge, and has years on the bench, that's terrifying. And just when you think it couldn't get worse, another nominee couldn't explain Title VI of the Civil Rights Act of 1964. That's the law that prohibits discrimination on the basis of race, color, or national origin, but only when federal funds are involved. This nominee tried to mumble their way through a vague, incoherent answer, and Senator Kennedy had to cut them off and give the correct explanation himself. Again, these people will be federal judges ruling on civil rights cases every single week. If you don't know Title VI, you have no business wearing a robe. Patriots, this isn't about gotcha questions or being tough on nominees. This is about defending the Constitution. We have men and women, American citizens, standing before the United States Senate asking for lifetime appointments to interpret the highest law of the land, and they can't answer questions that would be expected of a junior high civics student. This is what happens when the judicial selection process is politicized, when people are picked for their ideology instead of their competence, when loyalty to a progressive agenda matters more than loyalty to the Constitution. We need to stop this madness. We need senators who will stand up like Senator Kennedy did, who will ask the hard questions and hold these nominees accountable. We need judges who revere the Constitution, not those who are just trying to bend it to fit some woke narrative. It's time to wake up, America. If we don't demand constitutional literacy from our judges, we're surrendering the last line of defense between us and authoritarianism. We must restore integrity to the courts. We must raise our voices. If this fired you up, like it did me, then hit that like button, subscribe to the channel, and share this with your friends and family. Let them see what's happening behind the scenes in our government. God bless you, God bless Senator Kennedy, and God bless the United States of America.